Good afternoon, everyone. This is Judge Torum for the final pre-hearing conference number 5 in the Scout Clean Energy application for the Horse Heaven Wind Farm. Let me take a look first if we have someone from the applicant today.
Thank you. I'm Tim McMahon here, along with Ariel Stavitsky and Emily Schimmelfennig.
All right, thank you, Mr. McMahon. For Benton County today.
Yeah, Ken Harper, Your Honor.
Good afternoon, Mr. Harper. Counsel for the Environment joining us today.
Yes, Sarah Reineveld is here.
I hope everything is safe where you are, Ms. Reineveld.
We are just now safe, so thank you. Yeah, we just now have food and electricity. It's been pretty devastating over here.
I understand that Maui is not a fun place right now, so stay safe. Thank you very, very much for making time to join us today. For the Yakima Nation.
Good afternoon, Your Honor. Shona Volkers for the Yakima Nation, and I believe my colleagues, Mr. Jones and Ms. Houston, are on as well.
Excellent. Thank you, Ms. Volkers. And Mr. Arambaru, are you there for Tri-Cities Cares?
I am.
All right. Thank you. Any other FSEC staff want to identify or need to participate today? I know we have Ms. Grantham and our court reporter today. Mr. Thompson, are you on?
I am on, yes. I don't
All
need
right,
to participate.
thank you. Well, I hope not. All right, let's move on to the agenda items. And I think we'll talk about further refinements and the adjudicative hearing schedule that the applicant sent around today. Mr. Ramber, I did get your note and I just sent some suggestions about Mr. Simon. So it looks like we have our land use topics all down to 1+ days. Mr. Aramburu?
When you're ready to talk about Mr. Simon, let me know.
I will. Let me see what the first day's schedule truly looks like here. We've got our housekeeping built into every day in the morning. There will be some days we don't need it. So that may also affect particularly Wednesday, depending what we think about Mr. Simon's availability. I'm taking a look at where we are on the land use schedule there. And I think when we had talked last time, there was a question of Ms. McLean being recalled for other topics. Mr. McMahon, did we sort that out or was it Ms. Ragsdale?
Separate discussion about Ms. Ragsdale, but as to Ms. McLean, the issue there was the question of site retirement, and that hadn't been something we had originally thought about within the first day land use, but I think we can pick that up to the extent she has knowledge about the site restoration issues. I think we can pick that up on Monday.
Okay, so it looks like we've built in time for her before and after lunch. And the estimates look doable. And I'm wondering if anybody thinks there's any squeak time on Monday late afternoon that we might fit in Mr. Simon, or my preference, as I sent in the email just a moment ago, some point on Wednesday, whether that's during our housekeeping session or if we actually do end at 11:30, the meeting for the afternoon is not scheduled till 1:30, so we might be able to fill in a half an hour at that point. Mr. Aramburu, let me turn to you right now to see where Mr. Simon might get rescheduled if it really is only 45 to 50 minutes.
Well, thank you, Judge Torum. I do want to present a preliminary issue related to the entirety of the hearing schedule. We received just yesterday a brief from the applicant, and in that brief, it included some significant additional materials that were referenced for review by the council. These materials, though found in the brief, were not provided to us with the brief, and it was only when Ms. Volkers requested them that we received them. Included in that is material from Mr. Kobus concerning the water issues. Mr. Examiner, these are significant new matters, material changes in the project, material changes in analysis that have been received literally an hour before our final pre-hearing conference. We think that's plainly violative of standards of EFSIC, violatives of standards of due process. We were treated to these surprises at the just before the hearing starts, and also with no particular explanation of how this material is going to be given to the council itself. We also have outstanding our objection to the substance of the supplement to the Kobus deposition. We do not have rulings on witnesses as well. So we think that because of this significant late filed material without notice it was coming, that a continuance is in order for at least a month to allow us to review this new material that has just arrived today. To proceed without this continuance is to essentially have a hearing by ambush, by which additional material is submitted by the applicant, who knows how often, keeping everybody off balance and off guard. The memo that we received this morning, which is referenced in the brief, which is particularly important for this, and apparently is expected to be read by the council because it's a part of the brief, deals with multiple changes in locations of wind turbines, locations of projects, shifting the battery operations from one side of the project to the other, making changes in a variety of things. So the totality of this suggests that a continuance of at least a month to allow review of this material is entirely appropriate. And I will point out that this material has all been kind of foisted on us by the applicant without notice, without indication that it was coming, and without indication of how it was going to be treated in an evidentiary manner in this pre-hearing conference. So we think that due process, compliance with rules, attention to the public's participation in these proceedings indicates that a continuance of at least a month is necessary to review all of this new material. And that would indicate that the pre-hearing conference today should be canceled and a new one scheduled based upon a new hearing schedule. So thank you for that. I hope my motion is clear.
It's clear, and it's denied as far as the continuance. That should be clear as well. Let me turn to the applicant and find out exactly what this material was that was shared at 1:01 p.m. today, according to Ms. Stavitsky's email. Mr. McMahon, Ms. Stavitsky, I'm not sure who wants to speak to it.
Yep.
Mr. McMahon, I'd like to make sure the sound quality coming from the applicant's microphone has a little bit of an echo. So if you could take it a little slower, the court reporter can still get things down, but I want to be kind to our court reporter. Go ahead, sir.
Thank you, Your Honor. Can you hear me okay? Can you hear me okay?
I can, and that's a little better.
Okay,
yes,
great.
I can, that's a little better.
Appreciate the time. Gave me an opportunity to lower my blood pressure down a little bit in the last 2 minutes. So let me explain what happened here. We have been in a process with EFSEC for a very long time, where EFSEC asks us for data requests. We had indicated to EFSEC some time ago that we've continued to, as we go, modify the application to address things we learn ways to minimize and mitigate impacts, additional information that FSEC has asked specifically of us for their work as they prepared the final environmental impact statement. So we did, in fact, accumulate a number of issues that we were aware of that FSEC had asked us for in data request number 9. So we did submit that this week in order to be responsive to FSEC. We did cite in passing, if I had to again, I probably would have done it, but we did cite in passing a reference to the memorandum that we submitted to FSEC, and I believe there's also, might have been a reference to, look at Ariel, I think there might have been a reference to a 2023 updated wildlife report, which also we provide regularly to FSEC as they ask us for additional information concerning the project. So that's what we submitted. Now, I and our team here had certainly some sensitivity about doing that just prior to moving along with the testimonial process. And had I to do it again, I probably just wouldn't have put those references in the brief, but we did it thinking this information will be posted on the FSEC website and there will be access to it. The problem, of course, is that FSEC takes a bit of time to get stuff posted on the website. So this afternoon, we offered to the parties, and Ariel circulated to the parties, the memorandum, which was for data request number 9 to be submitted to FSEC staff. That's what we did. It wasn't an ambush. It was what we've done throughout these whole proceedings to respond to data requests that we've gotten from FSEC staff. And a lot of stuff has developed over the years, and a lot of stuff has developed over the last month. And so FSEC asked us to accumulate that change information, and we could have held off until the adjudication was done, which didn't make sense to me. We could have, and really we just had the time over the last few days to finish it up. The scout team had time to finish it up. There is no untoward motive here. It was all in an effort to be as transparent and open as possible to provide this information as requested by the council. Yes, it coincided with us starting with the adjudication. We will, if you want, if you think it best, Judge Dorn, we'll reissue the brief, taking those citations out of the brief. Happy to do that. And if there's anything else we can do to address this issue, we're happy to do that. It is simply an effort to provide the best information at the time it was requested of us by FSEC staff. Nothing more conspiratorial than that.
All right. Well, Mr. McMahon, I appreciate the explanation. I do see that there's essentially a 1-page cover letter and a 79-page memo. It is noted that it's responding to the final environmental impact statement that staff is working on and not directly related, other than the citations in the brief, to the adjudication. Aside from what you've stated and explained, Mr. McMahon, was there any intent to make that evidence as part of the hearing?
We're a little slow on the mute button here. No, in fact, we said that we did not intend to have this be part of the adjudication hearing. We recognize that this has been challenging. So no, that was not our intention.
Okay, let me suggest then, as I haven't got my finger exactly on what page this material is cited to, is it only on 1 or 2 pages of the applicant's brief?
It is, yes, Your Honor. I think mostly footnotes. No, I'm sorry.
Let me have you do.
Sorry, we're having
Go ahead.
We're having a mute button problem here. So yes, it's cited. I think in a couple of footnotes in the brief, and we would be happy to take those out.
Why don't you do this, as opposed to taking them out, so it's exactly clear to all parties on the line? Go back in and use the strikeout feature of Word. And
Sure.
If that's not helpful, I'm sure there's a Sharpie in your office. Black out that material if you have to do it manually and resubmit by close of business today. I'll make sure that staff that's on the phone here is able to let council know to use the version 2 of your brief as opposed to the version
Yes.
1. And they can, everybody will see that they're getting this. It's been stricken. And these attachments that you sent out today won't be part of the adjudication, but staff will continue to use the information supplied to them as part of your response to data request number 9. So I think we've now taken care of that particular issue of any ambush. And again, the continuance request based on that is denied, and now the evidentiary issue is taken care of as well. Was
Your
there
Honor,
anything else? Ms. Volker, go ahead.
thank you, Your Honor. Just before we move forward, if Yakima Nation, if I could make my own verbal motion for the record, understanding that all I have heard, we have our own motion to make, and I think that we should be able to make it on the record, and I'd like to do that before we move forward so that we're not coming back to the same issue.
Okay, is it in regard to what Mr. Aramburu raised or something different?
In regard to what Mr. Ramburu raised.
I'll let you go ahead and make your motion, and then we'll see if there's any additional rulings that need to be made. Go ahead, Ms. Volkers.
Thank you, Your Honor. The Yakima Nation has its own motion to continue the adjudication because of applicant's violation of WAC 463-60-116. Applicant cited materials in its pre-hearing brief that were not only unavailable to any other party, but actually also include extremely untimely modifications to the project design that is the subject of this adjudication, multiple witnesses' testimony, and other parties' own pre-hearing briefs. I would respectfully ask that Your Honor review the memorandum itself before ruling on our motion, because this is not simply an issue of striking footnotes. Applicant has provided absolutely no justification for its failure to disclose any of this information before this afternoon, and this proposed project redesign does not fit within what is contemplated under WAC 463-60-116. As Mr. McMahon said, a lot of information has developed, but it's not clear that this information was not developed this week, and it is directly relevant to this proceeding. Yakima Nation does not take its motion to continue lightly, as we ourselves have been working diligently to prepare in good faith, but it is truly unworkable to be responding to this level of gamesmanship in the midst of brief drafting, witness prep, and hearing prep. This new information presents a clear prejudice to our client, Yakima Nation. We have essentially prepared for hearing on a project that is now apparently no longer before the council. It is not reasonable to ask the parties to prepare for this new project design over the weekend. We haven't actually even been afforded the time to discuss this new information with our own client before today's conference. In order to ensure that all parties can cite to a fair record, the adjudication should be continued to allow sufficient response. The applicant has turned their proposal into a constantly evolving proposal, and Your Honor should draw a line and continue the hearing for the time necessary to ensure that all parties are talking about the same thing. It is clear the applicant is now talking about a different proposal than the one that we have prepared our cases on for the hearing set on Monday. Even if the applicant does withdraw its footnote citations, that does not cure the prejudice, because there are clearly project redesign conversations happening outside of the adjudicative process and outside of the information shared with the other parties. Thank you for considering our motion.
Thank you, Ms. Volkers.
Mr. Examiner, I would like to be heard as well, please.
Hold on, Mr. Rambert. This is the Yakima Nation's motion. I've heard you on your motion, and I've issued my ruling. Let me have the applicant respond, and then we'll see if there's anything that TCC needs to respond to that. Mr. McMahon?
Your Honor, this is Ariel Stavitsky. I can respond to this one. Our reasoning here is the same as our response to TCC's similar motion. I think this is really a product of these two parallel processes, this adjudication and the SEPA process, the data request process, that are proceeding in tandem. And Your Honor has
Hold on a second,
already
Ms. Stavitsky. I'm a little worried that you're speaking quickly, and I'm worried that the sound quality is deteriorating. So whatever Mr. McMahon did to improve the auditory sound quality coming from your conference room, if you would do the same and just slow down for me, and then we'll hear the rest of your explanation.
My apologies. I'll try to keep the court reporter in mind. I was stating that, this issue is really a product of the fact that we have these two parallel processes proceeding in tandem, the SEPA data request process and this adjudication. So as Mr. McMahon explained, these are ongoing. This is an iterative process and we are providing updated information to FSEC in response to their data requests. And so this is our attempt to provide, improved transparency, provide all parties with as much information as we possibly can, particularly given that I know that TCC and Yakima Nation have had concerns about the fact that, information as part of the EIS process is not making it into the adjudication. So this was not an attempt to ambush. This was an attempt to provide as much information as we can. But if, based on the timing of this adjudication, if it's too much to be providing this updated information, we can certainly, stall the clock and base the adjudication on not on this updated information. So, we're happy to respond however makes the most sense in terms of making sure that both of these processes can proceed uninterrupted.
Thank you, Ms. Stavitsky. Mr. Aramburu, anything to add to what Ms. Volker said in response to what Ms. Stavitsky said? Either way, I'll give you a few minutes. Go ahead, sir.
Yeah, I mean, the general response here is this is crazy. They've sent us a memo now that says, for example, remove all solar array infrastructure west of I-82. Remove solar infrastructure within 1 mile of I-82. Remove 4 turbines near Benton City. So it goes on with 11 pages of this. So the council has to understand what the project is before it. And the project has been changed by the applicant. It's not just a matter of deleting footnotes and other things. The project has been changed. So we're going to go ahead with days and days of testimony on a project that's been changed. That makes no sense of any kind, completely violative of due process. And I guess I would like to know what you're going to tell the council that the project is, because you're going to have to tell them that the project has been changed at 1:05 p.m. on August 10 by this memo from the applicant. Now, this makes no sense at all and is going to confuse council members, and council members are going to question why they're reviewing a project that's been changed by the applicant. It makes no sense of any kind.
Your Honor, this is Ken Harper. Can I be heard?
Of course, Mr. Harper, you're next.
Yeah, I'd just like to state for the record that the county joins in these motions. It is going to be a significant impediment to cross-examination. I've been working on my cross-examination, particularly of Ms. McLean, and now it is very difficult for me to understand how the cross-examination should be modified. Mr. McMahon's suggestion, or I guess his action of striking portions of the brief, does not actually address Mr. Aramburu's point, which is that the project is in a state of transition. So the county joins in the motions, and the county renews its earlier motion that this entire matter should be stayed until there's an FEIS and we actually have a project that's a fit subject for adjudication.
All right. We all know that I've already denied continuances based on waiting for the FEIS. There's not a basis in law to do so. That aside, I understand where the parties are coming from on a moving target. Mr. McMahon, Ms. Stavitsky, Ms. Schimmelfennig, would you care to give an explanation of why the applicant continues to make minor and or major changes to the original proposal that we first saw in the application for site certification filed on February 8th of 2021? And Mr. McMahon, if you want to take into account the ongoing debates or discussion of the project with council staff and how a draft environmental impact statement is being responded to with various recommendations for mitigation that are not in dispute by the applicant, and coming up with the update prior to the adjudicative hearing as required by administrative code provisions adopted by FSEC, and give the overview of what you think the council was expecting from the applicant and what the applicant has been trying to do by filing the changes, despite the frustration it might create for anybody trying to figure out what we're adjudicating here the rest of the month. So with all that as a compound question, please enlighten everybody on the call what the applicant's been up to.
Thank you, Your Honor. And it's not just what the applicant's been up to. We have gone through 9 data requests for the life of the project. This process is not one where you file an application and it sits there until the adjudication and then an approval is issued. This is, as Ms. Davitsky indicated, it's a 2-track process. It's an iterative process that we've been dealing with for the life of the project. And the other irony here is what's actually proposed with this information is a net reduction of impact. That's what we had been talking with FSEC staff about in terms of the intent of these modifications. And it is part of a process that we've been on for a very long time. We debated, should we just not move this forward right now? We thought in the interest of transparency, it was best to put it out there so that people understood it. And again, these are not modifications that are going to increase impacts or dramatically change the project. They're fairly nuanced, and they do in fact accomplish net reduction of impact.
And in your experience, which may differ from mine, has this been for other clients that you've represented before FSEC, essentially a parallel of past practices reaching back to things done in Kittitas County, things done at the Tesoro matter, which I don't think you were on, or the Whistling Ridge projects? Has this been the ongoing funneling down of impact prior to the council actually considering what's in front of them?
It absolutely has. In fact, the Whistling Ridge project, during the adjudication, literally live during the adjudication, modifications were made, like, when the process was underway. So this is really, in terms of the several projects I've been involved in, there's nothing different about this. It has to do with the way FSEC process works. And the idea is that as FSEC gains greater knowledge through all these proceedings, and it tends to, accelerate at this point in time, Judge Torn, because just a lot of information is being developed as we all learn more about each other's positions in the case. We are being responsive, and we are being responsive in a way that we've been directed by the citing council staff to provide information as it evolves and as it develops. There's nothing different here, frankly, in how this has been handled in the other projects I've been involved in, and no, I didn't represent Tesoro.
All right, well, I've heard from the applicants in response. I've heard Ms. Volkers. I appreciate what you've raised, what Mr. Rambrew has supplemented, and what Mr. Harper has added as well. Ms. Reineveld, anything you wanted to add on this?
So I have been out of internet access until earlier this morning and have not had an opportunity to review the pre-hearing briefs of any of the parties. And so I do not have the benefit of having reviewed the updated information fully that the applicant provided. I do think a continuance makes sense for us to be able to review the information, at least from Council for the Environment, if it is indeed correct that there have been reductions or serious modifications or mitigative measures that have been proposed in response to the new information. I know that I would like a little bit more time to review it with my witness. That said, I have not had the benefit of the other parties of reviewing the information because I'm just now getting internet access, but would certainly benefit from a brief continuance to review the information just so that we are all on the same page in terms of the actual project proposal that we're litigating.
Your Honor, Tim McMahon here. I want to ground this in a very specific actual thing that happened in the Kittitas Valley case, and I know that you were there at the time. During the adjudication and close to the time that the case was completed, the applicant in that case put on the table, and the citing council was happy to see it, a standard of 4 times turbine setback that would deal with a lot of issues raised by residential landowners. And that happened as we were in the closing days or moments of the adjudication of Kittitas Valley. There, and I don't remember, frankly, whether if there was controversy around that, but it was an issue of some importance to the siting council that we were able to resolve prior to the close of the adjudication. I could probably come up with other examples, but that's the one that really sticks out to me, Your Honor.
Your Honor, if I could respond to a couple of things that Mr. McMahon had said, I would appreciate the opportunity.
Go ahead, Ms. Volkers.
Thank you, Your Honor. I just want to clarify that our motion, while we certainly do stand by the original motion, continue and around the lack of FEIS, is not out of our motion today is not out of any confusion about what is happening between the applicant and FSEC on the SEPA side. It is about the need for substantive project modifications to be shared in a timely way. And I think that that is clearly supported by the WAC, which allows the applicant to provide this information up to 30 days before the hearing, but it's not supported to do it now. And while Mr. McMahon can state that there's a net reduction of environmental impacts, respectfully, none of the lawyers are the ones that can really testify to that. Like, we need time for our experts and their experts to be able to speak about that. And so I just wanted to emphasize that we're not saying that the applicant and FSEC cannot talk and through these information exchanges and requests for further information. But when it is a project design modification, that is a substantive change. And this last night or today, however you want to count this new information, it's not compliant with any rule. And we need some sort of line here that allows us to be talking about the same thing on Monday. So that's really what we're asking for here. And there might be certain positives that come out of certain modifications, but no one has had a chance to review this memo besides the applicant. And so we really need the opportunity for the folks that we've called to testify over the next 2 weeks to be able to make that analysis, not the lawyers today. So thank you for your consideration.
Thank you, Ms. Volkers. Mr. McMahon, this memo that's being referred to, that's the one that was circulated an hour before we started today. Is that correct?
That is correct.
All right, Ms. Volkers, I'm going to take that under advisement until Monday morning. At 8:30, we'll take it up again, and you can summarize the motion on behalf of the other parties as well, because I don't want to take an extended amount of time at 8:30 Monday morning. But I'll consider it. I'll take a look at the memo in the days ahead. My thought is that all the parties are going to bring Monday morning with them, their availability or not, for the week of September 25th through the 29th for 1 to 2 days of additional supplemental adjudicative hearing if I decide to grant the motion in part. So I want that material by the end of the day on Monday, the 14th of August. Everybody will have their availability for that week of September 25th to 29th. I may want an additional 4 to 8 hours of hearing time split over 1 or 2 days, depending on whether this raises truly any new issues that I think need to be talked about 30 days after the close of the hearing, which would set back the filing of post-hearing briefs accordingly. If I grant a motion to continue the entire hearing, I'll let you know Monday morning, but I'm not going to give you a ruling on that today. So let's move on to the original portions of today's pre-hearing conference. I appreciate the reaction time today to some of the late-breaking filings, so no critique imposed. Much as it's still baseball season, you continue to impress me with curveballs, all of you, and I'm going to do my best to take my time and before I swing at any of these pitches. So let's go back to the original things that were on the agenda for today. One of them was reviewing the schedule, and I want to come back to Mr. Simon's testimony. Given the discussion we've had today and what it may have an impact on Ms. McLean's cross-examination, I certainly want to take back anything I said in my late-breaking email 2 minutes before today's conference. We're not going to put Mr. Simon on Monday. Tuesday looks pretty full, my suggestion is that we either bridge Tuesday into Wednesday, or we run the hearing an extra half hour to 1 hour on Wednesday, August the 16th. Mr. Arambaru, can you make Mr. Simon available either late Tuesday and or late Wednesday?
Mr. Simon has a long scheduled trip to Alaska that
That's
he's
not the
leaving.
issue. That's not the issue. He's out for that week. Can you make him available next Tuesday or next Wednesday?
I can make him available, and I've been by way of email and phone conversations with him. He can be available at noon on Friday, August 25, which is when he is currently scheduled. Yeah, he will be getting off. He's stepping off an airplane from Alaska, but he can be available for cross-examination at that time.
Let's go with that as Plan B. I don't trust airline schedules to deliver witnesses to a place where it's quiet. Can he be available next week, since he's apparently not in Alaska next week?
My proposal would be Friday, August 25, which is on his return from Alaska.
All right. Are you willing, if he's not available within 15 minutes of the scheduled time, that he waives his right to testify?
I can't do that. I just don't know what the schedules are. He is scheduled to get off the airplane at 11 o'clock in the morning. I can make sure that he is by a phone at noon to be able to be available for cross-examination. But I cannot account for the vagaries of travel for these witnesses.
Yes, as I recall, Mr. Aramber, you had no control over the Blue Angels last Thursday, and I'm not going to grant you any control over what I presume is an Alaska Airlines flight from Anchorage. If he is to be made available on Friday, that is at TCC's peril. I am offering you, going once, going twice, going 3 times today, an opportunity to have him testify next week on either Tuesday, late in the day, or Wednesday before the council meeting. Would you like those options, or would you like to gamble on next Friday, the 25th?
I'd like to consult with him and get back to you by the end of the day.
All right, if you'll send an email with your selection, it'll be accommodated accordingly. So again, his choices are Tuesday, you roll back up to it, August 15th at 4 o'clock. Wednesday, August 16th at 11:30. I think there's a typographical error there. It should say AM. Or per your suggestion, Friday, August 25th at noon. Let me know your preference. If it's next week, we'll talk about it at the housekeeping session on Monday. If it's the following week on Friday, I'm putting it on the record today. If he's not available at the designated time, we'll check the flight number, and at my discretion and the council's indulgence, we may wait for him. But if he's not available, I'm not going to have however many people are on the line here today and the entire council wait for that flight to come in on Friday. That'll be a gamble that TCC takes or not. If he's not present to adopt his testimony, it will be stricken. Are we absolutely clear on that, Mr. Arambaru?
We disagree, but we're clear.
Perfect. All right, let's move on to the rest of the schedule. Is there anything else I need to know beyond what's obvious on the piece here? And again, the Wednesday, 11:30 a.m., we would fit Mr. Simon in with the swearing in of uncalled wildlife witnesses, which should take mere moments. That's why that particular time looks attractive to me. From the applicant, anything else I need to know that appears to be that the schedule might go sideways, so I can anticipate any dates that were, I don't know, discussions that happened offline, that there's any worry about the estimates from the applicant's perspective?
No, Your Honor, we believe that list that was just circulated is still accurate from our perspective.
All right, Mr. Harper, I know that Ms. Foster was covering the last couple of pre-hearings. from your review of all of this, does the county have any concerns?
No, Your Honor.
Ms. Reineveld, I know you've been out of internet for a piece of time due to the devastation in Maui. From what you've participated in and getting the schedule together, does Council for the Environment have any concerns?
No, Council for the Environment does not have any concerns at this time. Thank you, Judge.
And Ms. Reineveld, were you intending to have submitted a pre-hearing brief? In my accounting, I did not see one come in. I may have missed it.
Council for the Environment was not intending to submit a pre-hearing brief, but we will be submitting a post-hearing brief. Thank you.
All right, excellent.
Thank you for asking, though, because I wouldn't have been able to submit it yesterday.
Understood. I wanted to see if there was going to be any accommodation needed, but it sounds like we'll wait for post-hearing briefs from you, and hopefully the internet situation and the general situation is better.
Yes, thank
Ms.
you.
Volkers, anything else that I need to know about the schedule that the Yakima Nation is still concerned with?
Thank you, Your Honor. I would like to better understand the plan for Mr. Kobus's Stoll's recent motion to supplement with Mr. Kobus's testimony before confirming our agreement with the schedule as emailed on August 9th. We are in agreement with what was emailed and that we did workshop that collaboratively with Stoll, but I think that there's still a question that remains about Mr. Kobus's testimony, and so we'd like to wait for that to be resolved before we agree with this schedule in its entirety.
And Ms. Volkers, it's my understanding that Mr. Kobus does not appear on the witness list. Is that correct?
Correct, Your Honor, because this was developed before, this has been a work in progress, but the motion to supplement was just so recently filed that it was not accounted for on this list. And in fact, it was filed after we gave our final feedback to the applicant on the list that you have in front of you. And so seeing now that there is a proposal for him to sit for cross-examination, if Your Honor does allow that new supplemental testimony to come in, we would like to reserve the right to cross-examine him. And I don't know what his general availability is, but I think there's certainly time left at the end of the hearing for that.
Let me hear from Mr. McMahon or someone else at the Stoll Reeves office as to the intention and timing if that supplemental testimony is admitted in conjunction with his discovery deposition.
Thank you, Your Honor. Tim McMahon here. We notified the parties at the last pre-hearing conference that we were most likely to be submitting some supplemental testimony to correct some misunderstandings about the battery energy storage system technology and water safety around the BESS systems. We notified everyone last pre-hearing conference that we felt that was going to be necessary. We intended to provide some supplementary testimony in order to correct some information, to update some information. So we have done that. I recognize that Mr. Ambrew has strongly objected to that testimony. Our view is that it would be inaccurate to submit to the Siting Council prior information, design information, and prior information about the BESS facility, battery energy storage system facility, because that is just simply not, as described in the original testimony, just simply not the way it's going to be proposed to FSEC. So I apologize that it took some days to post together, because frankly, this was new stuff for me to learn and figure out. And it took a bit to have sufficiency in the technical information so that we could provide helpful information to the Siting Council to understand the safety issues around the BESS battery energy storage facility, around the BESS facility. So that's what we did. We felt that it was not productive or fruitful to give the council something that was not accurate. So we just tried to provide accurate information with that supplemental testimony.
One more question, Mr. McMahon, and again, slow down a little bit for the court reporter.
Sorry.
When
I
would
do
Mr. McMahon be, when would Mr. Kobus be available to testify? Would that also be on Friday, August 25th in the afternoon?
Your Honor, Mr. Kovas is along for the ride, and we will make him available if cross-examination is desired whenever it fits within the schedule.
All right, that's good to know. Ms. Volkers, once I have a chance to take a look at that supplemental testimony, if it is admitted, I'll let the parties know as soon as possible. It may be Monday morning at the housekeeping. It may then be something to renew if it is admitted, renew the motions or add to the motions a reason for the continuance and or the supplemental dates of hearing that I mentioned earlier. That would be, without looking at the council schedule, possibly the week of September 25th to 29th. Those are dates that I think are 30 days after the close of the hearing and responsive to the length of continuance the parties were seeking. So that's why I've selected that week to determine your availabilities. Mr. McMahon, if I do end up admitting the testimony and I believe that it needs additional time for the parties, that would be when I'd ask Mr. Kobus to make himself available for cross-exam. If I admit the testimony supplementally to go with what's in the deposition, and I think it's not something the parties need 30 days, then we'll see if he's available at another place in the hearing, but likely Friday, August 25th with some of that afternoon time. And we'll schedule it after the time that we might have for Mr. Simon, if that's the choice that TCC makes to present him, as opposed to the current scheduled time. So we'll take that matter up later.
That's fine. Thank you, Your Honor.
All right.
Judge, may I be heard on these matters briefly?
Certainly. Go ahead, Mr. Ambrew.
First of all, with respect to witness scheduling, we have been in contact with Lonnie Click from the Benton Fire District, and he is scheduled for Wednesday, August 23 at 9:30. Turns out he is not available on that day, but he is available on August 21 or 22. So we'd like the parties to accommodate, and there has not been a request to cross-examine him, nor was his testimony requested to be stricken. So it would be simply an affirmation of testimony.
I have no problem at all with that, Mr. Aramburu. If you'd let us know what day is most convenient for Lonnie Click to adopt testimony, I don't think the parties will object at all. We'll just, in a housekeeping session, move that to whatever day he's going to adopt his testimony. Is that acceptable to TCC?
That would be fine with us. And I do want a clarification about our position regarding Mr. Kobus's testimony. His supplement that he submitted to us involves a lot of technical material analysis of National Fire Protection Association standards and that kind of thing. So our principal interest is not so much to cross-examine him on those things, which he didn't seem to know anything about during his deposition, but rather to make sure that we have an opportunity to rebut that information with information of our own, given the late nature of what's been proposed here. So we are not necessarily asking for cross-examination, but we are asking for an opportunity to provide rebuttal to that material.
All right, and TCC may feel that way, but the other parties may wish to cross-examine. I'll let the other parties clarify with me next week on Monday at the housekeeping session, or as soon thereafter as possible, what their intent is. If there's nobody wishing to cross-examine, but simply more time to rebut and supplement the record, we can do that and give additional time for post-hearing briefs. Again, the extension that the applicant has is through January 31st of 2024. It's my understanding that we would have all of the materials in from the adjudication late this fall, and that the FEIS is on track to be presented to the council shortly thereafter. We'll find out from the appropriate FSEC staff when that timing is, and then the council will have its full deliberations on the entire record. So there's time, Mr. Aramburu, to get additional information from the parties into the record on the adjudication side. And when the FEIS is completed, it will also be before the council with sufficient time for them to make their recommendation on the entire record and the SEPA record up to the governor. So I want to assure you that on my side of the house, which is the adjudication, the entire record will be considered before any findings of fact or conclusions of law are drawn from the adjudication. And I am assured by the rest of FSEC staff that the council will also have the FEIS in time for their deliberations that go in conjunctive nature with what we're doing in the adjudication before any recommendation is made to Governor Inslee. All right, we've taken care of the schedule concerns. We've got Lonnie Click that'll be moved around according to that schedule. We've got Rick Simon to come on a different date than August 23rd. And we've got questions now about the continuance request to handle all of the redesign issues per 463-6116 and anything else that might come out of the COBIS deposition and the supplemental testimony. So we're going to move on from agenda item 2 to agenda item 3, which is a status update on the Yakima Nation's discovery request regarding water resources. Ms. Volkers?
Thank you, Your Honor. And I respect that you were moving on, but if I could finish my thoughts on the schedule, I think we got a little sidetracked with my comment on Mr. Kobus. I did have one more question for you on that. Okay. So, and then just to be clear, we will be asking to cross-examine Mr. Kobus if that testimony is submitted. So on the 21st, when we'll be requesting the closed record hearing, and meeting with my client this week, the question came up about viewing of the hearing for the council members, meaning the tribal council members. And so we can update our confidentiality agreement to reflect additional council members. But I wanted to make sure to understand if it would be okay to have multiple folks you just kind of in a room together viewing the screen, or whether or not FSEC would like a record of who all is participating in these hearings by being in the room for them. I mean, I think it's being closed at the Yakima Nation's request. So I hope that, there's not concern about the nation's tribal council members joining, but I just want to make sure that we're doing it in a way that's appropriate, and also that the people aren't accidentally excluded from the room with the technology that's going to be used. So I don't know if this is a question for Your Honor or for FSEC staff, but I just wanted to bring that up while it was front of mind to make sure that we're doing what we need to avoid complications on your end.
I appreciate that very much. Let's go over that Monday schedule with the cultural, historic, archaeological resource impacts and identify each session that needs to be a closed record hearing. I think the first one would be at the hour starting at 10:45 a.m. Is that correct?
I'm sorry, I'm having a little bit of a technical issue. That's the beginning of Ms. Lally's testimony, I believe?
Correct. So the Lally
Yes.
testimony is scheduled for 10:45 to 11:45, and again after lunch from 12:45 to 1:45.
Yes.
And then
Okay.
Your Honor, apologies. This is Ariel Stavitsky for applicant, and I would also ask this. I'm glad we're addressing this. Ms. Ragsdale also had the question whether her testimony would be held in the breakout room as private, and her position is that it's going to be difficult, I think, for her as well to determine in the moment what of her testimony is subject to the protective order and what is not. So her preference would be that her testimony as well would be all held in the private breakout room.
All right, so it sounds as though the morning session starting at 9 all the way through 1:45. Let me go back to you, Ms. Volkers, and looking at the rest of the day. Is any of that day not going to be a confidential breakout session?
Not, that's not- my expectation. My expectation, Your Honor, is that full day would be a closed hearing. I know that there's discussion about having the fire chief, just adopt his testimony, but for the witnesses that are listed there, we're asking that they all be heard in a closed record hearing. So I would expect that, yes, that would be a full day of a closed hearing.
Okay. Noted. I don't see any problem with the Yakima Nation who is forwarding this confidential information, having as many people in any room that you'd like, or tribal members that you and the rest of the elders determine are entitled to hear this information. If you'd like to have them sign on, I think that we should make sure that Ms. Grantham and Ms. Owens know who else to expect so they can add them to the list of people authorized to be in the hearing that day. It will also be something that we can make clear next week at the hearing and maybe send out a supplement to the notice that went out for the hearing that the bulk of the day on Monday, August 21st, other than Lonnie Click adopting testimony, if that's the date that works, that the hearing will be closed record because of the sensitive and confidential nature of the testimony. So that's Monday, the 21st. Are there any other sessions throughout the course of the hearing that are anticipated to be confidential in a closed record hearing?
Your Honor, from the Yakima Nation's perspective, the other time where there might be a request for closed record hearing would be on testimony around the project's potential impacts to the pronghorn population. And it's hard to predict how much of that, not knowing whether or not the council would have questions for Yakima Nation's own expert on that topic, Mr. Gonwales, which is why we we estimate half an hour, even though I understand that he, is not appearing for cross-examination, just because we weren't sure whether or not the council would have questions for him. And so that our understanding from last Friday from you was that they should be prepared to answer questions from the council. And so we built in that time. So it is possible that there would be time at the end of the day, Tuesday, during Mr. Romig's testimony, and Wednesday during the remainder of his testimony, or the swearing in of Yakima Nation's wildlife biologists. That's the only other time that I see on the schedule where we might be asking for that, and it's a little tricky to predict how long that would be right now.
All right, I appreciate that. So in summing that up, Tuesday afternoon at 2:50 p.m., depending on where the cross-exam goes and the redirect for Mr. Romig, and continuing on Wednesday morning at 9 a.m. For that testimony and redirect. Those portions may have sessions that require us to go into closed record. You're also saying that when Mr. Gonwales adopts his testimony Wednesday late morning, if there are questions and he needs to comment on the pronghorn issues, those may also require us to move into closed session. Did I get that right?
Yes, Your Honor.
Okay.
Your Honor, may I?
But I think it's helpful.
I just wanted to add, the same will likely be true of, there may be some need for confidential pronghorn testimony from our wildlife experts, Eric Jansen and Troy Ramig. And we were, just to throw it out there as a sort of logistical solution, we were thinking it may make sense to sort of have a pronghorn subject matter time of day so that could be held in the private breakout room, but defer to you and Ms. Volkers on how best you think that would work out.
And this was Ms. Stavitsky, right?
Yes, thanks, Your Honor. Ms. Stavitsky for applicant.
So Ms. Stavitsky, you mentioned Mr. Jansen, and was it Mr. Cook as well?
Mr. Jansen and Mr. Romig.
Okay, and we already had identified Mr. Romig as potentially having that testimony. So Jansen and Romig on Tuesday and Wednesday this coming week, and then the entire day on Monday, the 21st. All right, I'm going to make sure Ms. Grantham has taken notes on that, and if not, to reach out to me later to qualify or clarify anything, but we may be putting out an amended notice today or tomorrow that indicates that those sessions on Tuesday, the 15th of August and Wednesday, the 16th of August are anticipated to have closed record hearings, and that essentially the full day after the hearing opens on August 21st will be anticipated to be in closed record session. Were there any other witnesses that any party thinks will have confidential information that requires a closed record hearing?
Your Honor.
All right,
This
hearing.
is, oh,
Go ahead.
apologies, Your Honor. This is Ariel Stavitsky again for applicant. The only other thing we can possibly think may require a closed hearing is depending on your ruling on the pending motion to strike. If some of that testimony is allowed, there is certain trade secret information that may be required to be disclosed in a closed record hearing. And so that would be the witnesses likely affected by that from our perspective would be Rich Simon and Greg Poulos.
All right, understood. All right, parties, we've been going at this for over an hour. I want to have some mercy for the court reporter and anybody's late afternoon coffee consumption. So it's now 3:02. I propose we come back at 3:15 and get back on the record at that time. So we'll take a 12-minute break here and come back at 3:15, and we'll resume the agenda with item number 3, I believe it is. Ms. Volkers, I'm going to turn to you at 3:15 on the status of that discovery request, and I'll be prepared to give you a list of the outstanding orders I believe I need to get out when we get to item number 4, and then we'll go around again for number 5, and hopefully by 4:15 we can be done today, but I know we've scheduled it through 5 o'clock. All right, we'll take a recess now until 3:15. All right, it's now 3:15. Let me have a brief roll call to make sure that everybody's back. So the applicant?
We're here, Your Honor.
For the Yakima Nation?
Present, thank you, Your Honor.
Benton County?
Present, Your Honor.
Ms. Reineveld?
I'm here. Thank you, Judge.
All right, and Mr. Aramburu?
Present for Tri-City Cares. Thank you, Your Honor.
All right, let's resume with item number 3 on the agenda, status update on the Yakima Nation's discovery request. Ms. Volkers?
Thank you, Your Honor. We did receive a response to our discovery request. I think so that has been solved. I would like to note that we will likely have more once we have a chance to review the memo that was submitted yesterday, and that's the subject of the motion to continue.
You say that's the memo. Is it the same memo we've been discussing today?
Yes, Your Honor.
Your Honor, this is Rick Aramburu speaking. That the subject of the well is found for your notes, Your Honor, on page 8 of the memo under section 1.12. It has been made an issue for these proceedings.
You said page 8, section 1.12?
Correct.
Okay, thank you, Mr. Aramburu, for that refinement. Ms. Volkers, anything else I need to know about the discovery request?
Not at this time. Thank you, Your Honor.
All right. Anybody from the applicant want to confirm? Is there anything else outstanding you intend to be providing as continuing in this discovery request?
Not that I'm aware of, Your Honor, no.
All right, then we're quickly on to number 4, the what does Judge Torum still have to do? So you can cross out the if any. I understand that I still owe Mr. Aramburu and the parties my order on which witnesses are formally being moved from the TCC list that might be subject to adopting testimony and allowed for counsel questions and converting those to public comment. So that's definitely something outstanding. There's some other motions to take out, I think it's Mr. Simon's testimony that was stricken. And tell me for sure, Mr. Aramburu, if there's other portions for Mr. Crouppen. It looked as though he was listed for potential cross-examination. So there's still a motion out for both of those. Is that correct?
Your Honor, as I see your list, if I can put it that way, there is still an outstanding decision on our motion for reconsideration of inclusion of the testimony for witnesses Crouppen, Sharp, Dunn, and Simon, part of Simon's testimony. There is an outstanding motion by the applicant to strike rebuttal testimony of those witnesses, which is also opposed by TCC. The third motion is our motion to compel certain documents in our request for production. We have filed with you on Monday our response to that. So as far as we know, those are the 3 items that are outstanding that we're the most concerned with.
Okay, and I think by that listing, there's 4. There's the public comment versus pre-filed. There's the motion for reconsideration you detailed. There's the motion to compel certain documents and the Scout Clean Energy's opposition. And then there's the applicant's motion to strike rebuttal and your response that came in August 1st for the motion and your response this past week. I think I also have, Ms. Volkers, a motion. I think it's really going to be the agreed order we talked about last week on the motion to supplement. I think those came in since our hearing last time or since our pre-hearing conference. As I try to scroll through emails and find them.
Yes, Your Honor, that Shona Volkers, that should be in your inbox, and it just it took us a couple of days given all the other briefing, but we did circulate that and make sure that was okay with the applicant, the way that it was phrased. And also attached to my email is the deposition transcript for Mr. Kobus. The deposition transcripts and exhibits for Yakima motion to supplement were already provided. And I know that Ms. Massengale was making sure that those were all able to be put online as well so that anyone could access those once the order is entered.
All right, so that by my count, we're up to a 5th order, depending on 5A, 5B, however many orders, taking into consideration those motions to supplement from Yakima Nation. Does the applicant see anything more outstanding than those 5 that we've talked about so far?
Don't believe so, Your Honor.
Mr. Harper, was the county looking for anything else that I still owe the parties?
No, I don't believe so, Your Honor. Thank you.
For Counsel for the Environment, anything else that you were looking for that I still need to get to?
No, thank you. We do still plan on submitting supplemental testimony, hopefully today, from our witness. I was not able to submit that previously because of lack of access to internet. So that's the only thing outstanding for us.
All right, and do you anticipate that any of the parties will be objecting to that supplemental testimony, Ms. Reineveld? I'm not sure what discussions you may have had about that.
I do not anticipate that, no. 'Cause
Mr. McMahon, was the applicant considering, if you know what's going to be supplemented, any concerns with CFE's witness?
You know, Your Honor, that's an awkward question to ask or answer because we don't know exactly what it would be. I would say that before Ms. Reineveld went to Maui, we did talk about it briefly, and it didn't seem like we would have an issue. But I guess it's, you know, I would like to reserve the opportunity to object to it if there's reason to do so. I guess if I could just leave it at that. I don't anticipate though, because we did Ms. Reineveld.
Yeah, I'm not asking.
Yeah, sorry.
I'm not asking Mr. McMahon that you waive any right once you've read it, but I'm just looking for, should I be anticipating any further motions, whether in writing or verbally at one of our housekeeping sessions?
I don't think so, because I think we had a good conversation with the CFE, and so that's my answer. I don't think.
Okay. And again, I don't expect attorneys to be predicting with any better luck than I had in front of military courts martial telling a judge how long a witness would take. So I get it. On this side of the bench, it's a lot easier to ask for information than it might be to provide it with any fidelity. Let me go then to Mr. Aramburu. Any other items besides those 5 that, other than the pending motion we talked about earlier under number 2 in the agenda?
No, there's been the motion to supplement the Cobus deposition. We've filed a response to that just at 10 o'clock this morning. So I think that's on your list. And I do have one additional question. And it arises from this memorandum that we received at 1:05 this afternoon. On page 2, there is a discussion of the East Solar Array size reduction. And there's a paragraph that begins rationale for change. And the second sentence says, in a settlement agreement, Scout Clean Energy is committed to reduce solar generation from this location by approximately 100 megawatts. I have not seen a settlement agreement. And I think I'd like the applicant to explain what that settlement agreement is, and if one exists, that he make it available to us.
Mr. McMahon?
Thank you, Your Honor. Excuse me. Thank you, Your Honor. Yeah, we have, I would say settlement agreement, probably ought to say proposed settlement agreement. We, and Ms. Reineveld can step in here too. We had, during the spring in particular, we had some productive conversations with the Council for the Environment on a variety of issues to deal with some of her and Mr. MacGyver's concerns regarding habitat impacts and impacts on avian species and the like. And in that discussion, the applicant agreed to modify the East Solar Array to remove it, essentially remove it from habitat that was of concern to the CFE. So that is what that is about. And so we're documenting that we have minimized the impact of that area.
And so no settlement agreement yet been signed or submitted to the council, is that correct?
That is correct. No agreement has been signed or submitted. And Ms. Reineveld can weigh in here, as I understand it, such a thing would have to be approved by the Attorney General's office anyway.
Yes, that's correct.
And
Go
go ahead, Ms. Reineveld. I wanted you to address
Mm-hmm.
also the timing of when that might be submitted and what, if any, other, from CFE's perspective, negotiations or inclusion of the other parties was done or is needed. So let me have you start again.
Yes, we had early settlement discussions, and they did particularly involve mitigation to the East Solar Field. So Mr. McMahon is correct. I mean, I don't think anything has been decided other than I think those have been brought to our office and up the chain. We've considered them, but have not definitely arrived at any sort of settlement agreement. Those discussions are on hold currently. And from my recollection, we did involve all the parties in those initial discussions, and The settlement proposal was shared with all of the parties, the most recent settlement proposal. So this should not be a surprise pertaining to that discussion, if my recollection is correct.
All right, and
This
again,
is
if
Rick
it's a settlement
Rambrew.
hold on a sec, Mr. Rambrew. If it's a settlement between just counsel for the environment and the applicant, Mr. McMahon, that would not preclude the other parties from either commenting on, objecting to, or continuing their own positions, but simply reflect a settlement between the applicant and counsel for the environment. True?
That is correct, Your Honor.
Correct.
Mr.
And then
Rambrew?
I just wanted to clarify my statement that I do believe we shared that proposal with all the parties. So I think that they should have received that.
And Ms.
I will
Reineveld,
say-
they're free to sign on. They're free to sign on to it as well, but they don't have to, correct?
That's correct. At this point, no one has signed on to anything.
All right,
Well,
so if CFE and the applicant enter such an agreement, you would welcome the other parties to either sign on or indicate via the adjudication at some point that they don't concur with whatever the stipulation might be. Ms. Reineveld, is that correct?
That's correct. If and when we do, yes.
Okay,
And-
now,
and-
Mr. Aramburu.
I'm speaking for myself. My inbox is filled with emails on this case, but I do not recall receiving any draft proposals or discussions of a settlement agreement from either the applicant or Ms. Reineveld. Perhaps I've missed one, but I have not seen such a document.
Mr. McMahon, given
sorry.
Ms. Reineveld's position and other things that should have her attention when we hang up today, would you care to provide any of that email traffic, forward it to Mr. Aramburu, and copy Ms. Reineveld so she'll know what's been sent? And of course, copy the other parties.
Sorry, Your Honor, we spoke over each other for a moment. So that's a request of the applicant, forward that to the other parties.
Correct. And I don't need to see it because it's not involving the council, but certainly if it's something that staff's been involved in, then copy the appropriate staff. But I'm asking you to relieve Ms. Reineveld of the obligation today on Thursday while she has other things to attend to.
I'd be happy to do that, Your Honor.
All right. So Mr. Aramburu, hopefully your inbox will get even fuller later today.
Yes, and
All right,
thank you, Your Honor, for helping with that clarification.
No worries. On the agenda then, I've got, it looks like 5 orders that I need to write, and the motion today regarding Mr. Kobus' supplemental testimony that I have under advisement. We may be able to deal with that on the record next week. So I've got some homework to do. Let me go around the room, then we'll switch to item number 5, and we'll see what other miscellaneous or last minute questions. I think we've brought up the settlement agreement and the other supplemental testimony that may be coming in from Counsel for the Environment. But let me ask the applicant if there are any other last minute questions or concerns before we convene everything Monday morning at 8:30.
No, Your Honor, as far as I'm aware, no. Just a moment. Yes, right. I was gonna do that. For Monday, I intend to get cross-examination exhibits out to the parties for the land use section of the hearing beginning Monday, so they can expect to receive that from us tomorrow.
I'm sorry, what was it you're going to circulate?
Yeah, cross-examination exhibits for land use.
All right. And if those are exhibits, let me again, since you mentioned that word, indicate to the parties. I've consulted with Ms. Massengale about the screen sharing issues, and I know we had in the technical shakeout on July 25th, watched Mr. Aramburu share with success his screen. I'm hoping that all the parties will be able to do that themselves. And if they're planning to have Ms. Massengale put anything up on the screen on their behalf, that those exhibits be identified by number and that she affirmatively respond to you that she will have that ready to share on your behalf. As it turns out, there have been some other duties that are going to distract Ms. Massengale from being on call during the hearing the entire dates. So if we're going to make use of FSEC staff, I just want parties to reach out in advance, but otherwise be prepared to share your own screens so that council members will be able to see things and will go on with any of those exhibits. Mr.
Your
McMahon, does
Honor,
that work for the applicant?
Yes.
Mr. McMahon, does that? Okay,
Yes, thank you.
Ms. Volkers?
if I could ask, in the interest of clarity and also making sure that we're kind of all working off the same. So I had planned to ask Ms. Maskingale's assistant, so it would be helpful to know how far in advance she needs that information, and with the understanding that then if we don't provide that to her, we could still share the exhibits, but we would need to do it ourselves. Did she have a timing request on that?
I don't think Ms. Massengale's on the call today to speak for herself. If she is, I'll ask her to speak up now, but I think she's out today.
This is Andrea Grantham. She is out today and tomorrow as well.
Okay, so Ms. Volkers, what I'd suggest is that Monday morning at the housekeeping session, or if you'd like to send an email prior, just sometime early next week, or depending on the date you're going to ask for her assistance, that we identify which parts of the hearing session we might want to have her or another member of FSEC staff assist. But certainly, Yakima Nation will be permitted to display those exhibits that we need during cross-examination or for the supplemental testimony. I believe it was a PowerPoint presentation to help walk through one of your witnesses' testimony. So we'll get it done one way or the other. I just wanted to make sure. I had made some promises for Ms. Massengale and overpromised on what I think her schedule is going to allow her to deliver. If parties need assistance, we will find a way to get those exhibits up on the screens and in front of the council members so everybody can see them. But I just need to know those things in advance, probably by at least 24 hours, but 48 would be preferred. And that would be the same for any other party seeking assistance with displaying exhibits during the hearing. It's just really a troubleshooting matter to make sure we have it ready to go so there's not any delay given the tightness of the schedule that we have. Ms. Volkers, that address your concern?
Yes, Your Honor. We will continue to do our best to get all of that in an orderly fashion so we can share with Ms. Massengale.
Okay. And while I've got you talking, anything else that you wanted to bring up as outstanding issues before Monday morning?
Thank you, Your Honor. If you could humor me, I just want to make sure that people can see me on camera. I've been trying to work with our technical IT support staff. So if you or anyone else, I just turned my camera on. If you could let me know whether or not you can see me, that would be great.
Ms. Grantham, I'm not on camera today myself. I'm calling in by phone. Is Ms. Volker's camera working as far as you can tell?
Yes, I can see Ms. Volkers.
Okay, thank you so much for humoring that. And I don't have anything else at this time. Thank you, Your Honor.
All right. Mr. Harper, anything from the county?
No, thank you, Your Honor.
Mr. Aramburu?
I don't see anything further for the day. It sounds as though our housekeeping, if we want to call it that, session for Monday, setting aside a half an hour for that may not be enough. Perhaps we want to start early.
Well, I think we have a question as far as people's availability. We should be able to bleed into the 9 a.m. to 9:30 a.m. adoption of uncalled land use witnesses. And what I might do, Mr. Aramburu, is let the parties or the council members know that they don't need to be on until 9:15 on Monday to take care of Ms. Wadsworth and Mr. Wiley. But we'll see where they are. And if we need to go to 9:15 for housekeeping, we will.
Thank you.
All right. Ms. Reineveld.
I guess my only question is, I assume there's no objection to having expert witnesses listen to the prior testimony of witnesses in their subject matter. But I wanted to ask the question as to what the protocol was pertaining to expert witnesses participating.
Ms. Reineveld, my understanding is that there's no need to have them excluded. They've all had a chance to read each other's direct testimony. They've all submitted their testimony. So I'm not worried about like a normal trial where credibility or people sticking to somebody else's story might come up. All the evidence that parties expect to come in has been disclosed. So I would have no concerns unless a party can make a very rational objection why any other person or expert testifying should be excluded from any other witness's testimony. So that's my initial take on things. There may be an exception to that, but I think it'll be incumbent upon a party to let the others know that they want someone excluded, and then during housekeeping on the day of, not now, during housekeeping on the day of, let me know if there's any such concerns with people that should be excluded beyond the arrangements we've made for the confidential closed record portions of the hearing. So, Ms. Reineveld, I hope that addresses your concern. Your witness certainly, I don't think, would have any, they'd be wanting to listen into the other wildlife testimony, I'm sure, so they can respond to anything that they hear. That would make sense to me. Does that answer your question?
It does. Thank you, Your Honor. And that's correct.
Does anybody want to voice a general concern now as opposed to the instruction I'm giving you to let me know the day of witnesses if there's anyone to be excluded? Mr. McMahon?
No, Your Honor, thank you.
Mr. Rambrew?
I don't have anything further, Your Honor.
Okay. And Ms. Volkers, any concerns with that?
No, Your Honor, thank you.
And Mr. Harper?
No concerns.
Okay. I think we've gone around the room. Let me see if FSEC staff has anything for me or the parties regarding technology issues or scheduling questions. Ms. Grantham, are you aware of anything I need to raise today that hasn't already been discussed?
Not as of right now.
Okay, you'll let me know Monday morning if needed. Mr. Thompson, it's your chance to participate. Anything?
No, thank you.
All right, then with that, it's 3:39, almost 3:40 p.m. We are adjourned.